Hello everyone, welcome to the class. This is session 12 of e-marketing. As you'll notice, we are covering chapter 5 today. As I promised you before that we'll come back to this chapter because these are the issues. These are quite important issues related to e-marketing. So that's why I decided not to do the social media yet, instead to come back and do the chapter 5. And this is the last session. Before I start this session, just a couple of announcements. As you know, this is the last session. After that, you'll have a day break, and then we will have a final exam. The final exam format will be a lot similar to the midterm, except that you'll have a little less time but more questions, so just be more prepared and make sure you read those chapters which are mentioned in there, which will be covered. Also, the previous session which we have covered, which is related to integrated marketing communication or online marketing. In this case, you will see the marketing mix, which is the communication mix which we have used. That I have kept it intentionally short, but there is part 2 of that, which is a video on Google. I have uploaded both of those. Make sure you watch those together. In other words, first watch my lecture and then watch the Google also, because that part will also be covered in the final exam. Focus on the products of Google which are mentioned in the video, because there will be questions asked, as I said, from Google video as well. As far as this chapter, let's have a look at the objectives. We will compare and contrast the ethics and the law. We will discuss the implications of the ethical codes and the self-regulation. We'll also identify some of the main privacy concerns within the traditional and the digital context. We'll try to explain some of the important patent, copyright, trademark, and data ownership issues which are related to the internet. And finally, we'll highlight some ethical and legal concerns which are related to the online expression. So moving along, I would first talk about the short case which is at the beginning of the chapter. It highlights how easy it is, for example, to copy software. A lot of us don't know about it, but whenever we are trying to copy a CD, as you can see, for example, it says copy infringement occurs when people download copyright software without a license, loan a software to others for which they have no licenses, or install software on more computers than allowed. This is called the copyright infringement. So in other words, the counterfeiting occurs when illegally copied software is duplicated and distributed on the large scale. These are important concerns because you might think that it's not such a big deal, but let me give you an example which might highlight the importance why it should be done. So for example, if let's say you develop a software after graduating from college, if you like this field and you decide to write a software which you think maybe business people will be using it and it'll be very useful for them. So you develop a software and then you start selling that online. Now you would of course like to sell that. It's almost like writing a book and then now you're selling the copies of those books. It's the same way for your software. If, for example, you keep on selling those and everybody buys those copies, that'd be great. You'll be encouraged. You'll like that. However, supposing few people buy that and then they copy and distribute it illegally without your consent to other people, in which case it will hurt your sales. So now the fact that you are selling less, you will probably increase the price of your software in order to compensate it. So that is not good for the customer also. And similarly, if your sales goes down, it means people are just copying that software even though it's a good software. They keep on copying, but they don't purchase from you. It means you are not generating any more revenue. It will discourage you. You will not write any more software because you'll say it's not a good business. I'm not going to be writing that anymore. And that's the whole idea behind this, that by using this copies of the software illegally, you are discouraging the owner of that software to be creative and develop some more good software though. This is where the reason, this is why companies are trying their best to stop this practice. Uh, you can read the figures in the book. It is amazing that how many um, copies of software are copied in various countries. Companies like Microsoft and other, they are really trying their best to stop this practice. As you can see over here, it says globally over a third of the software sold is an infringing version, which means 1/3 of the software are just copied without making payment to the owner, and those people are just trying to make what we call the fast buck. In other words, these are all illegal copies which are being distributed there. Of course, we'll further discuss that in this issue, in which we'll say that, why is it that people in these developing countries, they are copying the software, and what should the companies do? Because if you look at it from the point of view of the developing countries, people might say over there that we can't afford these are very expensive software, and that's why it encourages them to copy. But in any case, we'll come back to this issue later on. But as you can see, this case highlights the issue, in which case it hurts the software companies. Microsoft is trying to remedy this situation because Microsoft gets hurt a lot. It's a big software company, as you know. It proposed the intellectual property legislation, and it also files the lawsuits in the local area. So I can share with you the information what was going on in Dubai when I was there. That that being a small place, they had come up with the rules that we will check the companies. They would be checking the companies as soon as if they found out that this company is using software which is copies of software without licenses, then they would be fined. And Microsoft was very active in those lawsuits, civil lawsuits. So it really did discourage the companies to do that. Of course, they did not go as far as going after the individual because that's not an easy task. Okay? On the other hand, it creates a non-infringement technology such as the digital right management security program embedded in the software. So Microsoft is also using, whenever they prepare those CDs, they use the digital rights management security program by which they cannot be copied. The other action which they are taking is that they believe that education is the best weapon against piracy, and they should educate the people of doing that just like we are doing over here. You might argue that this probably is not the best way, but this is what Microsoft believes. In any case, let's go back to the first topic, which is ethics and the legal issues. Both the ethics and the law are integrally related. Ethics is more towards the individual. It's the individual's own thinking, but on the other hand, the law is when it is done at a larger scale by the society, in which case laws are made so that they are um, then followed through and everybody then applies by the law. But ethics is something which is inbuilt, which is, you know, they are similar, both of these are similar in an essence, but ethics may be directed towards individual or group endeavors. On the other hand, laws are normally created for broader purpose with the goal of addressing the national or sometimes international populations as well. So ethics frequently concerns the values and practices of professionals and others who have expert knowledge of a specific field. Ethics is also a general endeavor that takes into account the concerns and the value of the society as a whole. Lots of time we say that in case if, to give you a small example, we know that lying is not good, but this is on the individual basis we say it's unethical to lie, but there are no laws which would say that if somebody lies, then you will put behind bars, unless there are laws which are hurting the society as a whole in the sense. So if it becomes so common to lie, then the laws are implied from that point of view. Also, a law attempts to be consistent in both time and place, so the citizens will be familiar with their rights and the obligations as well. Modern technology presents challenges to marketing ethics. Critical issues which are related to e-marketing that includes the ownership of the intellectual property. So as an example, if someone has written a book and published it online and they are trying to sell it also, and of course they claim this is their book, what if somebody, because there are so many billions of websites, what if somebody copies it and then sets up on their own website or starts selling it with their own name on it, saying that I'm the owner of that? So how do you protect that? And as we all know, in the electronic media or in the digital media, it is very easy to do that as well, to copy it and then claim it to be on their own. Similarly, the second issue is the law of privacy in the virtual world. Because of the fact that there's a lot of information out there, where do you draw the line? The individuals, when they provide the information, it would be out there and sooner or later somebody will have that. But where do you draw the line, whether the information which you have provided, is it being kept private or not? So as an example, in the case of a pharmaceutical company, for example, if when you and we for example go to a pharmacy and we have our prescription from the doctor, so we give them that prescription and then they give the medicine to us, and now of course they have this information that we may have some kind of disease or the medicine for which we are taking, the purpose for which we are taking this medicine. This becomes in their database. Of course, now the question is, are they keeping it private or are they publicizing it or giving it to other companies, letting them know that we have this kind of issue, so maybe that company could send us information for the purpose of, promoting their products. Again, this is an issue which we'll discuss also. This is the role of privacy. Freedom of expression is another one. In some part of the world, somebody might say that I'm publishing this something, which is based on, the fact that I'm free to express myself. But in other parts of the world, the same thing could be held as something against the culture, and there are limitations to that freedom of expression. Similarly, the use of data and its collection, this is very similar to the role of privacy. So when, to give you an example of a bank, let's say the bank has got the facility to ask you to apply for a loan online. So they ask you the information about your salary, about your family, about your job, etc. Now this is the data the bank will have when they are collecting that. Certainly you assume that I'm giving this data so that it would be kept in, but can they use this data after they have collected it for the purpose of promoting products, not only themselves, but also some of their other subsidiaries might be using the data in order to offer you products like life insurance, like car insurance, etc. So again, this is a question mark there, the ethics about it. Status of children and the digital work is another very important area in when we talk about e-marketing. What kind of websites need to be exposed to the children, and where do we draw the line, and what kind of items we can promote to the kids, and at what ages. So for example, the gaming industry, when they are promoting games, what kind of games are they can promote to what age groups. That also is very important ethical issue which we will talk about. The industry keeps on saying about the internet that we will do what is called the self-regulation. We'll self-regulate ourselves. In other words, or if you think about advertising industry, in some part of the world they have the Association of Advertisers and they have the Code of Ethics, and they say we'll regulate ourselves rather than getting dictation from the government. This is why in the US, for example, the recent US administrations have left the development of the internet to the free operation of the market. So what they believe is that the internet needs to self-regulate rather than government getting involved in there. There are both supporters of the self-regulation and there are critics of the self-regulation as well. Supporters of the self-regulation stress that the private sector's ability to identify and resolve problems. In other words, they're saying we are the private industry, we have full capability of trying to solve our problems. We don't want the government to get involved in it. So this is why, for example, you see the Code of Ethics for e-marketing, Code of Ethics for digital marketing, they call it under the American Marketing Association, in which they have come up with these rules so that the marketeers can follow through those. But the critics argue that the incentives for self-regulations are not really sufficient and true deterrence will not be achieved if the government does not pass some laws. Now this is why some governments are coming up with what is called the e-commerce law, and I'll discuss that later on about it too. Recent policy-making activities indicate that the governments are asserting themselves in the areas such as fraud prevention and the children privacy. So as you can see, I just said that there are areas on which governments are working. They are very complicated. They are very time-taking. In some governments, it takes years to come up with the e-commerce law. So as you can see over here, the fraud prevention is one area which, again, as I said, I will go into more details in a little while. So the first one, the privacy. The concept of privacy encompasses both the ethical and the legal aspects. It means what is private and what needs to be kept. Is it against the law to do that? And what are some of the things which are unethical practices? There is a constant debate regarding privacy, and it has proved to be an elusive concept both ethically and legally. Within a society, the privacy interests compete with the concern of safety, economic, and need for association with others. When we talk about privacy, let me take you to the next slide, which talks about the privacy in the digital context. Conflict that about how data should be collected and used, these have developed. As we learn that there are more and more technologies by which data about us could be collected in a number of ways without even our knowledge. And this is where the technology is available, so that's why we need to be concerned about it. And American Code of Ethics of Marketing on the Internet, it talks about information collected from customers should be confidential and used only for expressed purposes. So if I gave you the example of a bank, if I'm applying for a bank loan and I have given them online information, I have filled out a form, given them that information, I certainly gave them just for the purpose of that loan. I don't want them to use my data for any other purposes. Online advertising firms such as DoubleClick have traditionally recorded user click stream to form user profiles for marketing purpose. Now, the business of DoubleClick, some of you might be familiar with that. They started this business trying to follow through the click stream. In other words, they were following the trend of the people and what kind of websites they are and what they use based on also their behavior. Then this DoubleClick was gathering the data. And then once they were gathering the data, they were trying to sell that too. They were doing this, but however, it became really an issue once they acquired a company, and this company had the physical data of number of consumers and the customers. And this company, DoubleClick, when they bought them out, of course there was a big concern that now all of this physical data will be digitized, and then everybody, even though they are not online, their data will be available to DoubleClick too. So the controversy arose when DoubleClick acquired consumer names, addresses, and buying histories and planned to combine the offline data with the click stream data. This is where the government got into action, and then the government stopped them into this practice, and then questions were asked whether what is legal here and what is ethical. Okay. So for this purpose, let's go back to some of the ways by which data could be collected by the marketeers. Data, number one, is obtained through the use of digital cookies. Some of you should be familiar with the cookies. These are small programs which are in the background of our computers, and they are packets of data created. They're storing these packets of data into users' hard drive in response to instructions received from the web page. So now these cookies are saving that data. It could be your name, your other information about maybe even your passwords about the website on where you visited. So this way, next time when you're visiting that website, actually the purpose is different. The purpose is that supposing you might have seen that if you visit a certain website and they say that, do you want us to store your password? And if you say yes, that's where it is stored into cookie. So it stays in the computer. But then cookies also serve many purposes. One is create shopping baskets to hold purchases. also recall stored sales information. So for example, if you've gone through a certain website in which you were trying to buy something, but then you were either busy or you did not have time for that purpose, or you didn't want to complete the purchase at that time, so it will be stored in the background. So next time when you visit the website, it will inform you that we already have this information. So they collect this user data. However, the cookie allows the marketers to pinpoint an individual's online behavior. As I said about DoubleClick, this is exactly what they were doing. They were pinpointing the individual online behavior. So for example, if you have been purchasing airline tickets online using a certain website, now these cookies will have that data, and this data then could be picked up by DoubleClick or other companies and then sold it to other travel agencies, online travel agencies, and then they can start sending you information that saying that you should buy tickets from them rather than the other company. So obviously this is an area in which you have not approved them for that, but they are still doing it. That's where the ethical ramifications come in. Secondly, the debate about policy and on the privacy. Access to the personal data is another important online privacy issue. Cutting-edge applications raise additional issues. These are what we call the intelligent agent or the hostile applets. Applets are small applications in which case your data is being stored and then provided to the companies in order to do the marketing. Of course, this is where we say that it is unethical. While federal laws relating to the internet privacy remains in debate, many offenses can be addressed by conventional statutes, like, for example, Fair Credit. This Fair Credit Reporting Act is the U.S. Act, or the Electronic Communication Privacy Act is also an act. I may have shared that with you in this example before, but banks, for example, or credit card companies, as an example, American Express, they decided to, they had lots of data, they decided to rent this data to other companies, and then some of their customers found out about it, and they were really upset. And for this reason, American Express had to go online, I'm sorry, go on the media and advertise big ads in the newspaper apologizing the customers for this act, and then they said that we will never ever use the data to sell this data or rent this data to anyone, and we'll never use this data for any other purposes other than what the customers have told us for that. So that comes under the Privacy Act, though. Certainly, we are talking about these kind of acts in the US or other developed economies, but when we talk about the developing countries, this becomes a big issue because they don't have any specific regulations about the data, and this is where a lot of issues may be happening. One other issue is about Children Online Privacy Protection Act, or the COPPA, established policies for ethical collection of information from children 12 or under. Now, certainly some companies might argue that we are just collecting it for the purpose of demographics, for the purpose of what people like, or what kind of games, as an example, like, and what they don't like. And this is where we are saying that there are some boundaries to that, and that's why there is no problem if you're collecting the data ethically, in which case, and without undermining the children's privacy. Privacy within the electronic mail remained an unsettled aspect of online interaction. We all go through this thing, we all receive hundreds of thousands of emails in the form of spam. So this is where there are issues, and one of the issue, of course, is that it is Much cheaper for companies to go ahead and send millions of emails in one click. But they don't realize that when the other party is receiving those email, it is affecting the brand image. So this is why good brands will never do that. If you're talking about international privacy issues, there are various areas the FTC has identified the following norms for the ethical use of consumer, and they are available on the uh, page 124 and 125 of your book, and it talks about the use of consumer information, the ethical use of consumer information. The first one is called the notice. In other words, it's saying that users should be aware of the site's information policy before data is collected. So as I mentioned to you previously, that these cookies or other information which is being gathered in the background, the consumer need to be told about it. And this is why, as you know, uh, when you're using your personal computer, you have a right to block those cookies or remove those cookies from that as well. So notice should be provided before collecting the data. Number two, consent. The users should be allowed to choose participation or exclusion from the collection. In other words, you first ask the users whether they want they would they want you to gather the information or not. If they say yes, then only you can use, and that is called opt-in. Opt-in means that you are authorizing the company to gather the data, and opt-out means that you are not. You're asking them to take out their name from those various areas from which they want you to collect that data. Access. Users should have the ability to access their data and correct them if erroneous. Sometimes there is data in the database about individuals which may not be the correct data. So for this reason, individuals should be allowed to see that data and see if it is correct or not. And if it is not correct, they should have the right to get it cleared. Um, in this case, I'll give you an example of the credit rating companies in the US, especially when people want to apply for a credit. Sometimes they're surprised to see that in their data in the database under their name, there's a lot of information against them, which goes against them, saying that you have not paid your bills or things like that. And of course, they should be given the right to challenge and see that this data, what was the basis of that data. So now they're allowed, and they're when they challenge this, then the companies which are holding that data, if they cannot prove that this data is correct, then they have to remove that data. Okay. Security. Policies to ensure the integrity of the data and the prevention of misuse should be in place. Policy should be there in case whether what kind of things they are doing in order to secure the data. So as an example, if I go on Amazon and order some books and they ask me for my credit card information, I give them that credit card information. Now I get the book, but how am I sure whether the credit card information I gave will not be used for any other purpose too later on? This is where we are talking about security. We are saying that if I have allowed you to use the data, if I've given you some data, how do I know whether it is secure? So in this case, if for example, maybe one of the dissatisfied employees of Amazon copies this data and steals that data before leaving the job and then goes and start buying things on the same credit card information which I gave them, who would be responsible for that? And this is why the law now clearly says that the company which did not secure the data is responsible for that. So in this case, Amazon will be responsible. For this reason, now companies are making sure that the data, if they gather, is secure. So one of the things that they're doing right now is that they are storing the data of your credit card, for example, in two different places so that even the employees do not know what kind of data or which is the other data. And this way, uh, they cannot steal the data as well. Finally, the enforcement. Users should have effective means to hold the data collected to their policies. This is similar to the or to the security one. So enforce rules so that you can safeguard the data which you have collected about your customers or individuals. The next area I want to talk about is called the digital property. The law protects the intangible or intellectual property through three basic mechanisms. Because now we're talking about digital. When we're talking about some inventions, for example, in that case we have the copyrights law. Mainly what we call the patent laws are there. It is for the invention purpose when you are inventing something, and the patent laws are there. But we also have the copyright, which addresses the issues of expression, which means that what is the copyrights? It addresses the specifically the right to publish or duplicate the expression of ideas. The trademark is concerned with the words or the images used to identify a product in the market. It is important to note that these categories have been flexible and often the boundaries between them have been modified by the legislation and the court. So trademark, so if you have a certain logo, it is very easy to copy that online, but how is it protected? It's, for example, a logo of a certain company cannot be used by any other company because this belongs to this specific company. The patent, the first one, as mentioned in the previous slide, there are three things. So the patent is the first one. Applying patent law to computing is an uncertain but developing field. Patents prevent competitors from doing the same thing a different way. Because when you have patents, so for example, if there's some new way of doing things online, maybe you can get a patent to that, and this way the patent, if you are protected by the patent, the others cannot protect that. Others cannot use that way, and you will be the only one using that. But the problem is patent protection has been claimed for reverse online auction and the secure credit card processing. So in this case, the courts have sort of argued that these online auction, reverse online auctions may not be the areas to be patented because online auctions have been going on for ages. If somebody has done reverse online auction, that may not be the protected by the patent too. Secure credit card processing, some companies were doing that and they felt that the patent should be given, but the court has still not allowed that because then it means that only there will be a monopoly of this company, just the credit card processing. They want to have more competition in there. So the US Patent Office has decided to increase the rigor of reviewing application for software related protection. I'm sure you can see from here that how complicated this area is in the case of patents, whether they should be giving the patent or not. Very challenging. Secondly, the copyright. Copyright is the primary means of protecting most expression on the internet. For example, the doctrine of fair use. In other words, the ability to copy protected material for education or news reporting. If you are using some published material, it has to be copyrighted. In other words, nobody should be able to just take part of that and then either claim it to be his or hers or just copy it without informing the user. So we can think of the published research papers or published research which could be copied easily over there. But for the purpose of education, yes, it may be allowed, as you will learn about it later on. Then we also have doctrine of first sale, limit the ability of the copyright holder to obtain profit after the initial time at which the material is sold. So supposing a company has sold the books in the beginning, they should be given the right copyright for that, and others will have no right to then resell that product without the information of the individual. It's almost like saying, as we said about the software, that if you bought a CD and you had the music in there, the purpose of that music was for you to listen, but it does not give you a right to take that music and put it online, or you put it online and start selling to other people. This is where we are talking about doctrine of first sale. We have, of course, certain laws here related to the US, but this is an important Digital Millennium Copyright Act law, which contains to protect the ISPs or the Internet Service Provider from act of user infringement, criminalizes the circumvent of the software protection, and complies with the international standard for the copyright material. These are important because some of you probably know that in the case of music, this became a really critical issue because people were buying music and then sharing the file. This was called the file sharing software, which became a big issue. And then the owners of the music were suing these companies that why do they allow this? But the companies were saying we are only a platform. People are just using this platform to share with each other those files. And of course, in the end, they lost the case and they were not allowed to use. So now, even if you are sharing files, that is considered illegal. And for this reason, as you all know, Apple became the first one to come up with this application or the apps, and whereby you can purchase the apps at cheaper price rather than sharing the music for free. Trademark laws concerns the ownership of the intellectual property that identifies goods or services. These are applied to the internet and in the naming system. We all know of the what we call the internet um, numbers or the IBAN, in which case we are getting the so it's called the ICANN, which is the Internet Corporation for Assigned Names and Numbers. So it's almost like registering your website address or your name. That is where it becomes your trademark and nobody else can use anywhere in the world that trademark. So similarity in the names may result in trademark infringement claims also. There was one time in the beginning when people started registering those names under their names. So there were places like Kazakhstan where there were some individuals who were registering the trademark Coca-Cola and Pepsi dot their Kazakhstan.ka. Obviously, it became a big problem because when, for example, Coke or Pepsi wanted to go and set up their website, then they were told that this name is already taken. So this is where they became a big problem. They had to sue those people because the court then said that anybody who has been using this name for years anywhere in the world should be given the first right, and that is related to the trademark. A trademark violation, cyber squatting, involves the registration of domains that resemble or duplicate existing ones. So this is what I'm talking about, that if, for example, instead of Coca-Cola, you register Coke, or instead of Pepsi, you register PepsiCola.com, then that would be considered a duplicate, and then it will be then given back to the Pepsi itself. And there have been a number of cases like that. Next, we move to the licenses. They are an increasingly popular method of intellectual property protection. Licenses allow the buyer to use the product but restrict the duplication of the distribution. So licenses are given for the purpose of basically uh, increasing their sales, but at the same time with the consent of the buyers of these companies. There are two types of that. One is called the break the seal licenses, in which case you are not giving them the right of the whole software in itself, but the clip wrap is the licenses in which the user is required to click to accept the terms and the conditions. So for example, the license of using an accounting software could be just basically using it for the usage purpose, and then the other one could be in which it could be modified according to the need of that individual, of that company or individual. Legal trends favor the enforcement of software licenses. Data ownership. Legal and ethical debates about data access and ownership questions have come up. Online technologies such as click data, spidering raise concern about data ownership. You see, spidering is basically when you are trying to gather the data without the consent of uh, the owner. This is a complex issue involving the online data. The process involved the use of software application called robots to enter the target website and obtain data for the use of its owner. So if, for example, you are providing, let's say you are giving your credit card information and your personal information to a certain company, these spiders might just get this, steal this data on while it's on the way, and then copy it somewhere and then give it to the other owners, though, which of course will undermine uh, your legal information. The movement is growing to protect data related to facts, namely specified compiled databases, because it's easier now to store the data, so that's why the laws have to be brought in. We also have online expression, as I mentioned to you in the beginning, that what is the boundaries of the expression. In one culture, maybe you are saying I'm expressing myself, but in some other cultures, there might be a limit to that, how much you can express and how much you cannot. Also depends on the government. Some governments do not allow, the freedom of speech as much. Internet technology has resulted in what many consider inappropriate or untargeted types of consumer contracts. Spam, we have already told about. Expression directed to children remains a highly visible issue in online laws and ethics. The boundaries of expression will continue to be challenged by the internet, because on one hand, on one extreme, people are saying no, we should be free to say what we want to say, and on the other extreme, it's the governments and the societies are saying no, enough is enough, we want to put some lid on it, and there must be some kind of boundaries as far as what could be expressed and what could not be expressed. Finally, some emerging issues into what is becoming hot research areas as well as for the governments. This is about the online governance to resolve conflict remain. There are some issues related to the domain naming. There were only few companies which were registering the domains, but now because of the fact that countries like China has become very big in the sense of using the internet, and especially the Chinese language is being used a lot, and the trend now is that we should be allowing the different other uh, let's say other than the English alphabets to register the websites too for the domain name. And some of the laws have been passed, and there has been some kind of progress made too, though. So, for example, I know of that in the Arab world, in Arabic also, you can start registering the domain names too, and I would not be surprised that in China they have already started too. Jurisdiction is the ability of the court or other authority to gain control over a party. Uh, this is another area. In other words, supposing if you purchase something online and this company is claiming that they are based in USA, but their account is somewhere in the in some other free export free zone in which the US does not have any access, or maybe some independent banking where is done. So in this case, if this company does not deliver to you the goods, and if you claim that I want my money back, who should you go and complain? This is where the problem is. Treaties may provide for international resolution and enforcement as well in case if this something like this happens. Another emerging area is the fraud in the use of deception and the false claim to obtain profit. Some people happen to falsify their identity online and claim to be someone who they are not. One example is in the case of the oil spill which happened in the US a couple of years ago by Shell, they by BP, and there was somebody who was claiming that he is the representative of BP and kept on giving statements online, which was really creating a lot of confusion among the customers out there. And of course, you can imagine the frustration from the BP in itself because those statements were not their statements and there was somebody else using those statements. So that could be something which needs to be tackled online, legally as well. So companies, or as it says here, the FBI and state agencies have increased their efforts to track and prosecute such fraudulent conduct too. So as you notice, we have covered a lot of issues. In this case, they are related to e-marketing. And as I mentioned to you in the beginning, that normally I cover this in the end so that now you can appreciate what you have learned, all those marketing mix as well as the marketing strategies, and see what are the limitations to these e-marketing practices too. That should take care of it. If you have any issue, please feel free to write me or contact me by my Skype. And also, when you're preparing for your final exam, if you have any issues, please feel free to contact me, and we will see you on the exam day. Of course, I will be sending you email regarding the final exam later on. Thank you and have a good day.